Hi there, this is Erick Widman from Passage Immigration Law, and I'm actually outside on a beautiful Portland day. We moved up from California to Portland to enjoy the beautiful green trees, and yes, it does rain a lot, but even in the middle of January, you get some lovely weather. So figured head outside and do this live Q&A from the forest of Portland. And in fact, we've got a couple exciting developments with our firm. Our director of operations, Allison, right now, I think, at this very moment, she's headed into our Los Angeles office, specifically in Glendale. And I asked her to hopefully take some pictures social media wise. This is our new office down there. And we're looking to post those pictures up. We already have two really happy clients who gave us 2 5-star reviews so we're off to a great start for Los Angeles. And then this Friday, our business immigration attorney, David Lee, he and I are going to be meeting up this afternoon, that Friday afternoon. He's driving down from Seattle, and so he's overseeing our Seattle office in the Georgetown area. So we're so excited that we've got the West Coast pretty well covered. Portland's right in the middle, but then Seattle and LA are enormous opportunities. And so we're looking forward to helping lots of people there as we build our team and build a body of really helpful information. We want to keep producing videos and blog posts and provide just a huge amount of free educational information, legal information, because there's a lack of that out there. It takes time, but it's definitely a worthwhile investment. So we're going to get better at videos, get better at producing content, and eventually release some free courses too. We have Kajabi as a platform, and so that's super powerful to do that. So stay tuned for more content coming your way, and of course I'll continue to do this live Q&A on Wednesdays. Might even expand some more. To your questions. Okay, we got a number of really good ones. First, what is the probability of a B2 extension being declined if you have already filed an N600? So for context for everybody, B2 visa, it's for visitors. You cannot have immigrant intent for that. Also, to have a visitor visa, you're not supposed to be a US citizen. You don't need a visitor visa. You don't need any visa if you're a US citizen. So some people might have already been a citizen and were filing the N600 to prove that. And that's to get a certificate of citizenship. So sometimes based upon where your parents lived, where you lived, whether you were born in or out of wedlock, a number of complex factors come into play. The year you were born, because the rules really changed in the year 2000 with the Child Citizenship Act, all of that plays a big role in the process of getting a certificate of citizenship through the N600. But this question is really interesting. So if you have a current B2 visa and you're trying to get that visitor visa extended, but you have a pending N600 to show that you're already a US citizen. And I wonder if, excuse me, I wonder if this came from a current client. We're currently working with someone on this issue. If USCIS finds out that and determines that, yes, you are a US citizen, are they just going to deny your visa extension? I think that is the logical outcome, but it won't happen soon because these big bureaucracies are slow and very slow moving. So I think you still want to do the B2 extension, because what if they deny your N600 or say that you need more evidence? So that's the only way forward. But if you're a citizen, then you really don't have to worry about your visa anymore. You'll take your certificate of citizenship. And actually, an ex-client just texted me to let me know that he traveled without a passport. He just traveled with his certificate of naturalization. That's not the best way to go, but he was able to get through the border and he got put into secondary inspection. He just had a certificate of citizenship, and the CBP officer said that was key for getting through. So, long answer to your question, keep doing what you're doing, but it is possible your visa will get denied. That's the logical outcome, the B2 extension for that. You had a follow-up question. If it's declined, is the probability of the actual visa being revoked due to the N600 application? And yeah, what's the probability there? Yeah, it might. Yeah, not certain about the probability. So much of law is not scientific, but so I would give my best guess about that. You might have it revoked. Similar effect to the being declined, but they would take away the whole thing in that instance. But again, you're a citizen, so you're okay. Okay, next one. My family has 2 processes, one for TPS and one for a green card. We just received a request for biometrics for the TPS application. Should they still go to this appointment? Sounds a little familiar, but I think this was submitted again this week. So definitely go to both appointments, continue both processes, keep the TPS one going, do biometrics. Even though your green card is on its way, it's a nice backup that you'll have your work permit for TPS, and you already paid for it anyway for the TPS application. So keep it going. Backup, redundancy for you IT people. It's just good to have backup. Next question. I have not had my green card yet after filling out 2 I-90 replacement green cards in 1 year. What's the reason? Thank you. So the I-90 form, you fill that out to replace or renew your green card, and you submitted that in 1 year. If you had submitted one and you hadn't heard back, you should keep following up on that original application. And it is possible to confuse USCIS, unfortunately. I don't think a second application necessarily would have done that. Crazier things have happened though. So the best thing to do is with your original first I-90, focus on that because that was filed first. That has set essentially like a priority date in motion, the filing date. You've started the whole process. Then call USCIS, follow up, do an e-request, check to see how long it's taking for these to be processed. And COVID has definitely stretched out the processing time. But my understanding is it should be issued within a year, even at the worst, slowest spots around the country. Something is probably amiss. Also check that your address is correct with USCIS. Okay, next question. My sister came to the US through Afghan parole, but her husband is still in Afghanistan. Can she apply for her husband to come to the US? She also has a baby, which was born in the US. So yes, I feel so bad for so many Afghans suffering because of US government mismanagement, because of failure to take care of people around the world who are our allies. It's really horrendous. And so, yes, you want to, and many law firms like ours and other nonprofits want to help Afghans, Iraqis, others around the world who have helped our country so much. You're specifically wondering if your sister got Afghan parole, which might have been through an SIV, the special immigrant visa, or it might be most likely a humanitarian parole that was broadly encouraged for Afghans to pursue. If she got humanitarian parole, but her husband's still there in Afghanistan. So her baby is now born in the US. Can she apply for her husband to come to the US? So yes, pursue a humanitarian parole application for the husband. You're going to want to show a compelling need, the danger to his life, the compelling reasons he needs to be here. But yes, the processes are kind of fluid in that family members, when we've filed a number of these, but family members need their own application. So yeah, look into that. Get in touch with us if you need some more general information. But yeah, pursue it. And similarly, and the next question: my cousin's 15 years old. He came through Afghan parole, humanitarian parole. Can he apply to invite his parents? And his parents have SIV. So it's not clear from the question if they have an SIV. Humanitarian parole is a good thing to apply for. We're seeing approvals. We're also seeing a slowdown in that process. So definitely look into it. We would say as time passes, there's probably it's going to be even more difficult to get humanitarian parole for Afghans, maybe because people just get fatigued with the numbers of so many needy people, and so the government might become less sensitive. Kind of what's happened at the southern border, where the Biden administration is really insensitive to the needs of people seeking asylum. So something similar is probably already happening and will happen in the future. So the sooner you file, the better for humanitarian parole. Okay, moving along. We received a USCIS notice of action, a rejection notice saying the payment amount was incorrect. We don't understand that. We have proof through our bank that the check cleared by USCIS in June for $12.25, and that's for the Form 485. That's how much you need to pay for that. So they're saying that the payment amount was incorrect, but they cashed your check, and that's always a good sign when they cash your check at the lockbox. So look to see that the notice of action for the rejection is for the 485. Maybe it was, if you're doing an adjustment of status, was the rejection notice perhaps for the I-130, which is a different filing fee. I think it's $535. And the other thing that I'd highly recommend for everyone wondering about the correct filing fees, there's a great tool. My Chrome browser crashed. I can't believe it. I hope it's working. That was terrible. Well, sorry about that. But there's a great tool out there, my USCIS calculator tool. And I tried to look it up online here, and that caused my browser to crash. That's very unstable. But you can type in the form that you're looking to confirm is that you have the correct fee for, and this USCIS calculator will ask pretty detailed, accurate questions to make sure that you are getting the right information so you can send in the right type of check. In addition, what's good is USCIS has said they're going to start accepting more credit cards and bank transfers, and filing online allows you to ensure that the filing fee is correct. So it takes away this frustrating process of you write the check, if it's wrong, they reject your application, they send the whole thing back. So online applications are better for that reason, in that you have to get it correct in order to submit it. Okay, I'll continue on here with the next question. One of the documents required by the NVC is my parents' birth certificate. What if my parents don't have a birth certificate? What if they never had one? We're from Yemen. Okay, so what you should look at, and this is also helpful information in general, is a visa reciprocity chart with the U.S. State Department. And you can see what the U.S. State Department considers to be required for each country. And so in certain countries, many developing countries in the world, you don't have fully accurate records. And even in India, a developed great nation, they don't have accurate birth certificates, especially for people who are our grandparents' age. So the visa reciprocity table, the chart, and you put those magic words in the Google, look at the visa reciprocity table, and you'll still look for Yemen for your case regarding that question, and they will explain what you need from Yemen and what to do if you don't have a birth certificate. And so quite often there are some good alternatives. And so, for example, in many countries, you can provide sworn affidavits of the birth that was witnessed by your uncle or aunt or your parents. It gets tricky with parents because many people typically are not around. No one's around who viewed your parents' birth. Hopefully that's the case, but as time passes, people pass away. So you'll look at alternatives to the birth certificate, but start with the visa reciprocity table, see what the State Department is saying, and I'm double checking. Yeah, it's at the NVC. So they should be giving you guidance as well, specifically on what is required. And the second part of that question, my parents lived in Somalia 40 years ago, and in 2015, they moved to Egypt from Yemen. Do they need a police certificate? So they were there. Often these police certificates are required if you've lived in a place for more than 6 months. Look carefully at the individual requirements for each country and each embassy. So depending on where they're doing their consular interview, there's a good chance they are going to be required to get them from Somalia, Yemen, and Egypt because they lived in all those places. But there's also a minimum age. So if you're too young, if I believe some embassies, maybe all of them, say if you're under the age of 16, you don't need to list those out. Double check that though. I'm providing all this information from memory, and this information, not legal advice, is something you should double check. Next question. Is the DNA test still required when applying for parents? And what do I have to do? The I-130 just got approved for my parents, and their case was sent to the NVC. Does receiving, well, I'll start with, there's a second part of that. So the I-130 was approved. Congratulations. The case was sent to the NVC, the National Visa Center. That's part of the Department of State getting the documents ready for the embassy where the interview will ultimately take place. And so the specific question is the DNA test still required when applying for parents? Some embassies require this more than others, and it happens more often in developing nations where the U.S. State Department is more suspicious of birth certificates, of other documentation. So the embassy can require that. They don't always require it, but they're still doing this. And so if they required it before, they're likely going to require it again. It happens all the time in Yemen, in Afghanistan. We've had clients there, Iraq, a lot of those hotspot countries require it. So yes, be prepared for that. Okay, I'm going to apply for citizenship soon. My son is 12 years old. He has a stepmom who is a U.S. citizen. What will my son's citizenship application look like? Good question. Lots of great questions this week. So your son is 12 years old. His stepmom's a U.S. citizen. You're a green card holder because you're applying for citizenship. So you're an LPR, you're a green card holder. And once you naturalize, so he's 12 years old. So he was definitely born after the year 2000. That's when the Child Citizenship Act kicked in. And one of the benefits of that, so look that up, Child Citizenship Act, after year 2000. So my understanding of how this is going to work for your son is that he, thankfully, is going to automatically going to become a U.S. citizen as well. That is super exciting. Double check this. But I think you'll want to then apply for an N600, N as in Nancy, 600 form for your son. That's a certificate of citizenship. And thanks to the Child Citizenship Act, he's going to be in great shape because he's under the required minimum age. So I don't think you're going to have to worry about his stepmom because you're naturalizing. If for some reason I'm missing something, or you don't, the full picture is not here, or there's some other facts that might affect your case, stepmom could also help, given he's only 12. But I think most likely you're not going to have to do an actual citizenship application for him because of the Child Citizenship Act. Okay, well, there's tricky nuances with step parents and step kids, so it's possible there is a exception or nuance there. So look carefully at that. Next question. Okay, this is a pretty detailed fact pattern about an SIV, special immigrant visa, that it's really long, and I'm sorry I can't get through the whole thing here to give you some accurate advice. But the next question, though, is it possible to expedite an asylum interview? These have been horribly delayed. It's a disaster. We're talking to folks all the time who filed with either on their own pro se or with another firm, and they're wondering what's going on. You can certainly follow up and ask that the case get back on track. For example, we helped a woman who had applied for asylum. She hadn't heard. She'd been interviewed already. She has been waiting for 2 years approximately, I believe, perhaps even more. And those delays are pretty common right now with this huge asylum backlog. So you can follow up, and you should, and check in about your case. You could get a senator involved, which we do in some situations. We have looked at doing delay litigation for those cases, but are currently not recommending that because various factors. There's a higher denial rate with those mandamus cases. And just like any immigration benefit, you want to do it once, do it right, hit it like a sledgehammer with a high certainty of success. So mandamus lawsuit, we don't recommend that. We do recommend following up with USCIS and potentially getting a congressperson, congressional rep, senator, House of Representatives involved. Next question. Can I self-petition for myself? I'm a business owner and I have employees. So there are several potential ways forward. For example, EB1, employment-based first preference category. In some cases, business owners are able to petition for yourself, do the EB1 without the perm process. Then you have to essentially be extraordinary in your field as a business person. There is a new entrepreneurial parole rule. If you started a business, you're in the startup stage, that is promising. We started to look at that more recently, and that has potential. I think that USCIS is still rolling out the regulations and the rules for that, but the Biden administration opened that one up. So, but that's for startup operations for newer companies. So depending how long your company's been around, that will affect your profile, the size of your business. So you're looking for a green card. You probably have an existing non-immigrant visa, like an L or an E. An H-1B visa is also available. You probably already went through those options. I don't have the full context. That's what's tricky about these live Q&As, but still think they're valuable in that we can hit the high points. But self-petitioning EB1 national or the EB2 national interest waiver, those have potential there. And we're very excited that our expert business immigration attorney, David, is going to be cranking away at our business cases. And we're going to be, he's taking the lead in that department for us. And I'm meeting him this Friday in the Portland office. And then, final question is that I get asked frequently, are the rules the same in different states around the US? And someone asks, can we hire you even though I live in a different state? The good news is, yes, you certainly can. And we have clients all over the place, many different states. I don't know if we've ever had someone from Alaska, like currently. So at some point we want to do that. The rules, because of federal immigration law, are the same. We can apply for you and help you in any state and also across the globe. We were also asked recently, that's a tricky one, of whether we should expect any immigration reform to come through in the near future. Unfortunately, we are pessimistic about that. There was an opportunity that slipped by, and so we were recommending that people wait and see for certain types of benefits that might have been available under comprehensive immigration reform. And the Senate parliamentarian didn't play ball. She didn't want to allow a path forward through that whole process. So unfortunately, there's not a legislative solution coming our way anytime soon. I bet, and I haven't researched this recently though, that just like Obama did, he started looking at executive orders. Biden is going to start doing that as well. But there's talk about still trying to get a broader legislative solution. Sadly, it doesn't look like it's going to really happen since the new year is upon us. It was wonderful to connect. Let us know if we missed any of your questions. Also try to make the questions shorter, just a sentence or two. Since a big block of text, I wouldn't be able to get through all of that. But it was great to connect. Reach out, say hello, subscribe, and stay in touch. Take care, everybody. See ya.